Well, welcome back to It's Your Money Radio, where you can make more money, you can save more money, and you can have more money for all your financial goals. We're going to come back the end of the show now. For the next half hour, we're going to be talking to Heather Rooney McBride, and John will be interviewing her on trust.
Okay, well, this is picking up from a couple months ago when you were on the show. And I hope we get a little further because it's a good topic. And last time we talked about kind of what happens if you don't have a trust. Yeah. And now we want to get into what is estate plan?
Yeah, so my answer to what is estate planning is different than a lot of attorneys, I think. And that is that I want it to be a collaboration type process between you, for example, the financial planner, the CPA, maybe the banker, and me as the attorney, for us to work together and talk together with our mutual client to determine what's going to be the best plan for the client. And the plan can range from something very simple to figure out what would happen if the client is disabled or incapacitated in some way to what's going to happen upon their death. To a little more complex when we get into the topic of different kinds of trusts.
Mm-hmm. Right.
So it's an exciting topic to me, and one that I feel pretty strongly about. I was speaking with a client not too long ago who just felt like she really could not afford to do an estate plan, and that she just didn't have the money to do it. And we try really hard at our firm to have very reasonable prices on a basic estate planning package that will include a medical power of attorney, which is who's going to make decisions for you if you are incapacitated and a medical decision needs to be made, and then also a financial or what's called a durable power of attorney, which is who has the power to help you with your finances if you're incapacitated, who can write checks, who can talk to the bank or the mortgage company for you if you can't do so for yourself. And then also a simple will. We do those three things as a package at a very reasonable flat fee, because, which actually is about a third, frankly, of what most attorneys are charging for those things, because I feel really strongly that everyone, no matter what you have, deserves to have an estate plan and your wishes written out in a legal fashion that is enforceable after your death.
Yeah, I agree. And we talked last time about how if you don't have an estate plan, the state has one for you.
Oh yeah, let's talk about that.
And your assets might not be divided up like you want. You might not get the medical care that you've told your wife. I mean, you could have had a conversation. I'm a guy, so I say my wife, but you or your husband.
Yeah.
You might have had a conversation about, hey, if this ever happens, if I'm in the hospital and on in a coma for 3 weeks and there's no hope for recovery, here's what I want you to do. The wife may not have that right to make that decision unless you've put it in writing.
So it's really important that you set up who you want to make that decision. So in your case, if you want wife to be the first person to set up your wife as the primary power of attorney, and then to plan for, well, what if she's incapacitated too?
Or just sold all your tools for a nickel.
Well,
That's what I was thinking. That wife needed a trust, didn't she?
You got to plan for this stuff. So to have one or more alternate people to make those decisions. And then my power of attorney also includes what we call an advance directive. So what kind of life support techniques, if any, do you want? And so you're going to set out for the person that's making those decisions for you what your wishes are in a legal document, which makes it not impossible, but more difficult for them to override what your choice is as expressed in the document.
Right, because if it's left up to the doctors, their job is to keep you alive.
Generally so. And people ask me all the time, well, if I have a do not resuscitate order, I don't want them to shock me. Like, I don't want to be on a breathing tube. And so we have this discussion that you really have to rely on the person you've named as having your power of attorney to be an advocate for you in the medical process, because the medical people don't want to get sued, right? So if emergency gets called and you are not with us anymore, they are going to shock you to try to bring you back, regardless of what your document says.
Right.
So you need to make sure that you have the right people in place to make those decisions. For example, medical power of attorney and financial power of attorney, you may not pick the same people. For example, my mom is, she was a bookkeeper for a while, she's a professor, she's great with money, really great with money. I don't feel confident that my mother could make the decision to pull the plug if I didn't want life support. So I do have my mother named as an alternate on my financial stuff. I don't have her named as an alternate on my medical, because the idea being you want to pick people that can carry out what your wishes are.
Yeah, as long as your skin's warm, your mom's wants.
That's right.
Oh, yeah.
I'm gonna hang out for a long time if it's up to my mom.
Yeah. Well, yeah, and I see the necessity of having alternates. You get any more, you get in a car accident, you and your wife, in my case, we're both incapacitated, we both be on life support, then we should have someone like my son or someone else that may need to be.
Well, absolutely, and the same holds true for the upon your death scenario. And part of I do a pretty marathon estate planning meeting when I first meet a client or clients, because I really want to get to know who you are, who your family is, what your family dynamics are, to be able to assist you in planning in that process. But for example, let's say a couple only has one child. There is a distinct possibility that a disaster could occur in the form of a car wreck, for example, and everybody could go at the same time. If that were to happen, what do those parents want to happen with their estate? Who gets the assets in that scenario? If the nuclear family all passes at the same time, who's going to inherit? So to talk through some of those notably unpleasant hypotheticals is a really important part of the process to make sure that the state law does not apply if it doesn't match your wishes. And I find in most cases it doesn't apply. State law, and let's cover that for just a second, is going to provide that if you don't have children, your surviving spouse gets 100% of your estate, which a lot of people are not comfortable with. They want to, for often good reasons, they want to give to charity, or they want to give to their very close cousin that's like a sibling. If you are married and have children of that marriage, then $20,000 comes off the top, up to $20,000 to the surviving spouse, and then half of what's left to the surviving spouse and to the children. If there are children, but not of the marriage upon someone's death, then half of it goes to the surviving spouse and half to the kids that are not of that marriage. Most people have some sort of fraction that's different than that, that they will feel most comfortable with. And the only way to both avoid probate and override those defaults that I just mentioned is to prepare at least a will and potentially a trust.
Yeah. And the durable financial power of attorney, what does it take to trigger that?
So there are actually two kinds that are allowed in the state of Missouri. The one kind that probably you're thinking of is incapacity, which you get to define as you wish. And my default is when two medical doctors have certified in a writing that you are unable to handle your daily financial affairs, then the person you've named as having your power of attorney can take over and handle everything for you. And actually, the reason that I have two medical doctors, most attorneys only require one, is that I had some litigation years ago in the Boot Hill of Missouri. It was an interesting situation where we had a rogue doctor that was in cahoots with kiddos who were about to inherit a bunch of money. And so a second opinion is never a bad thing, right? The other kind of durable power of attorney is to make it immediately available, regardless of incapacity. So if I want to elect to allow my husband to sign my name on checks, on if he wanted to go sell our house on his own, he could sign as my power of attorney right this second. That is more rarely used, and I always have that caveat discussion of it requires a lot of love and trust, because that's a lot of power, right? If my husband can go sell our home and I don't have to sign. Granted, statutorily it's supposed to be for the best interests of the person that you're signing for. So they can get into a lot of trouble if they don't do that the way it's supposed to be done.
Okay, and Medicaid planning spend now.
Yeah, that's a fun and increasingly important topic
That's
these
one
days.
I talk to my clients about all the time, especially as they start to get a little older.
Yes, so I should provide the caveat here that I don't specialize in Medicaid planning, but it is an important element when you're contemplating putting together what's called an irrevocable trust. Okay? There are two different types of trusts, roughly speaking. One is revocable, which is going to avoid probate. You get to stay as your trustee, and you get to change it, amend it, add to it whenever you want during your life. And those are the more commonly used kinds of trusts. The irrevocable trust is one where you can no longer serve as your own trustee, and you're going to put an asset or assets into an irrevocable trust for a few potential different reasons, but a common one is Medicaid planning. And there's this thing called the 5-year look back rule, right? Where Medicaid requires you to be relatively poor before those assistance funds are going to be able to kick in. You're going to be able to apply and qualify. So the fun part about the law, which requires you to not go skydiving or do anything super dangerous, you got to outlive the 5 years, is that if I elect to title a $30,000 CD that I have into an irrevocable trust, and I keep that CD in that trust for a 5-year period of time, Medicaid rules provide that it will be ignored. It's not going to be counted as an asset. It's as if you don't own it, provided that you're putting that money into that trust to ultimately go to someone who's not you upon your death, right? And if you do that, then you're able to what we call spend down more quickly, look poorer sooner, right? Because the $30,000 isn't going to be counted, and whatever else you have is all that you're charged with getting spent before you would be eligible for Medicaid.
Yeah, the way I explain that to my clients too is if you have, we're not talking about super wealthy, but moderately wealthy. Say you have $500,000. Well, that sounds like a lot of money until you're paying for a nursing home.
Oh, that's right.
And then it's not a lot of money.
That's exactly
A couple
right.
years in a nursing home, that money's gone.
Gone.
And that may not have been your plan or your desire to take your life savings of $500,000 and have it disappear because you had to go to a nursing home.
Right.
Where with what we're talking about doing is taking that money and setting it aside for, first of all, it can be used to take care of you during your life.
That's right.
But it doesn't have to be used to pay for your nursing home care. If you meet all of the requirements, that money can be set aside. You can go on Medicaid and have the state pay for your nursing home and still have $500,000 to leave to your heirs.
Yes.
How you want it disposed of instead of just having it disappear. And that could be any kind of medical care costs. A lot of illnesses can cost that kind of money very quickly. And insurance doesn't cover everything. They have limits too. So, it's just there for the protection of your heirs.
It is. I've been doing a lot of irrevocable trusts lately for that purpose and in that asset level. Because people who are significantly more wealthy than that probably are investing and don't have to worry about it as much, right?
Yeah.
But people that are in that sort of, moderately wealthy range are wanting to protect their assets. And when they're going to pay out anything to themselves, it's important to note that that will be counted as income. by Medicaid. So if you've provided that I get $500 a month out of this irrevocable trust, Medicaid is going to count that as income to you. But the rest that's still in the trust will get ignored, provided it's in there for 5 years.
So I'm sitting here listening because I am at this table. I'm probably the oldest, or maybe in the room the oldest, but to do that. So that's an irrevocable trust. So if you had a,
Yeah.
okay. So can you do that? What type of assets can you put that on?
Anything. So I just closed one out where we put a lady's second home into an irrevocable trust. It was her vacation lake home, nothing major, but isn't going to qualify for purposes of the spend down. She's going to have to get rid of that in order to have Medicaid assistance. So you can put anything you want in it. It is sometimes a cost benefit analysis for the client to determine what they want to put in there that they can't easily access, right? Because it is an irrevocable trust. You're not the trustee of that trust. It's a corporate trustee or a loved one, and you need to not be in charge of that trust, because the public policy behind it is that if you can grab that money whenever you feel like it, we're going to count it.
So that should be part of the spend down for Medicaid.
That's right.
And I'm assuming by the spend down for Medicaid, and I know I'm getting closer to the Medicare levels, but is that if you can spend down enough where you're meeting the government criteria for the levels
Yes.
of income, then you can go on Medicaid to help provide your.
Yes, but you are going to have to go through a fairly rigorous process of proving that you have met those spend down requirements, receipts, bank account statements, and so forth. So it is important to get some type of assistance. There's a variety, and I don't know them off the top of my head, but sort of elder care free places that people can consult with and work with. But if you're also looking at salvaging assets to make sure they're not counted in the Medicaid planning process, you really need to talk to an attorney.
Oh, that's what I was thinking. I'm just, this becomes very interesting to me. I'm 62, so I'm slowly moving at least to the Medicare age. I guess we're all closer to Medicaid. Anything bad happens
Well,
to us.
you know,
That's true.
Medicaid isn't something we're trying to put people on, and it's part of a. In you know, when I'm talking to clients, it's part of a multi-tiered. I mean, they might talk to an insurance person about buying nursing home insurance and ask me how much nursing home coverage do I need, and you know, with a trust, an asset protected trust, you can answer that question. Without, you really can't.
Right.
Say how much insurance do I need? Well, all of it that you can afford, unless we do some planning. In that case, you can save a lot of money on the insurance, spend a little bit on the attorney, and make sure that your assets go where they're supposed to go.
And that would say that you're age contingent, so the older you've allowed to not get to the nursing home, the more that insurance is going
Right,
to
but you
cost.
could go to a nursing home, you know, in your 50s or 40s
Oh, yeah, I
or
know.
30s. I mean, you know, so that's something, if you have the wealth and you want to protect it, you know, this isn't, you don't have to wait till you're 65.
No, I didn't mean that, but I meant, what I'm saying is, so you talk about having some kind of insurance for nursing home insurance, that's age contingent. The older you get, the higher that gets, correct?
Yes, the
That's
more
true.
expensive that gets.
The more expensive.
And I usually counsel people to have this discussion and start thinking about this in the early 50s
Yeah.
mile marker. That's not to say that you couldn't have a catastrophic situation prior to that. You certainly could. But if we're just going with the general rule here, early 50s, if we're going to do a 5-year look back planning mechanism, you're probably going to hang out until you're 60 or above, such that we can meet that 5-year requirement.
But you could do it at my age,
Oh, sure.
assuming that
You
I'm
just
going to
can't
hit 60.
skydive or do crazy stuff that would arguably cause the situation to end
You
sooner.
don't have to worry about being skydiving. I scuba dive, but I can stop that. See,
Well,
hey, I don't mind going under the water.
one of the things I like about your service is you talked about, you do have a simple will process, and that
Yes.
fits for a lot of people.
It does. It does. And, you know, I worked for really large firms for many years, and they often tried to push or pigeonhole people as always needing a trust no matter what. And not everyone does. There are ways, and we call them non-probate transfers, to still avoid probate, so to not incur the time, expense, and public record nature that is the probate process, but to do a simple will with some very specified mechanisms for bank accounts, vehicles, real estate, that is going to avoid your assets having to go through probate. And I am a huge fan of only requiring people to do what they really legally need.
Well, we'll be talking to you again next week.
Yes.
She's going to be our guest again, and we'll go ahead and let me take care of the sponsors as we close the show. You've been listening to Heather Rooney McBride. She's Rooney McBride and Smith. Their phone number is 417-708-9681. Got Dr. Michael Miller. He's at Family Back and Neck Care. He's at 889-2225. He'll be here in a couple of weeks talking once again, probably about ketones to do that. And we've got, of course, our host, and sometimes I probably do the worst with John, is John Dittrich, MBA, CPA. He is with DB Advisors, and his phone number is 763-3345. He's been giving you a lot of the information today. To do that, I'm Gary Bingaman with A&D Mechanical Services. We're full service plumbing, heating, and air company. 866-8257 24/7. And then we have Marilee Doherty. She's with Clarity Insurance and Financial Services. Marilee can be called at 417-887-6621. And then, of course, we've got Gayla Scrivener. She's with Scrivener Solutions. You can give her a call at 276-6609. What are we going to be talking about next week?
Well, it probably will be a variety of things, but I think we're going to talk about forming your own business, sort of the do's and don'ts in that process.
Listen to us next week. Have a great week.